So, ever wonder what the 5 most important gun laws and statutes you need to know in Florida? Watch the rest of the video and find out. Welcome, everyone, to another episode of Musings with MGL. I'm your host, MGL, and once again, we're going to bring you a top 5 list here today. So, a lot of people keep asking me, hey, gun lawyer in Florida, what are the 5 most important laws I need to know if I live in Florida or if I visit in Florida when it comes to firearms? So you're in luck. We're going to go through those top 5 here today. So we're going to start off with number 5. We have no constitutional carry, okay? Don't listen to what anybody tells you about new laws that we've recently passed here in Florida. We do not have what's called constitutional carry. Constitutional carry means that you can carry basically anywhere you want, anytime you want. You can conceal carry, open carry, go to schools, go to churches, go to public buildings, courthouses, wherever you want to go. Constitutional carry means the Second Amendment is my carry permit. I don't need anything else, okay? We do not have that here in Florida. So if people use that phrase and try and convince you of that, they're wrong. What we have here in Florida is permitless carry, which means used to, in Florida, if you wanted to conceal carry a firearm, you needed to apply for a concealed carry permit through the Department of Agriculture, fill out paperwork, do your background checks, give them fingerprints, take a safety class, and send them a check. And then they would review all that. And if you qualify, you'd get a permit in the mail. It looks like a driver's license, got your picture on it, etc. And you have to carry it around with you. If you did not have one of those permits, you could not conceal carry a firearm in the state of Florida. The new law is called permitless carry. All it means is you no longer have to go through that process to get that little ID card to carry around with you. That if you want to conceal carry and you're eligible to get one of those cards, you just don't feel like doing all the paperwork and sending in the money, then you can still concealed carry. But the important thing to remember is you must be eligible for a permit. So the Florida statute 790.06 is the statute that talks about what the requirements are to get a concealed carry permit. If you meet those requirements, you can conceal carry without a permit. If you do not meet any of those requirements, then you still cannot conceal carry even with this new law, okay? So number 5 is we don't have constitutional carry, we have permitless carry, but check the statute to make sure that you don't disqualify yourself through any of those things listed there. And if you don't, then feel free to conceal carry. Now, number 4, kind of tied with that, is we do not have open carry here in Florida. Open carry is illegal, okay? Florida statute 790.053 says, except as otherwise provided by law, it is unlawful for any person to openly carry on or about his or her person any firearm or electronic weapon or device. So we don't have open carry here in Florida. As a blanket rule, we don't have open carry here in Florida. Now, there are a few exceptions to that. So there's another statute in Florida, 790.053, or actually 790.25 subsection 3 kind of gives a list of some exceptions to the open carry rule. So the general rule is no open carry. There are a few exceptions to the open carry rule. So for example, 790.253 H and J allow you to open carry if you're going to and from hunting, to and from fishing, to and from camping, or to and from the gun range. It also, under subsection N, says that you can openly carry a weapon in your home or your place of business. However, a guest in your home may not lawfully open carry on your property, even with your permission. An employee of your business can open carry at that place of business, but of course the owner may prohibit this and further may prohibit possession of firearms on their property. So the important statute is 790.25 subsection 3. There's a bunch of alphabetical things in there that give you the exceptions for open carrying. As long as you're doing one of those exceptions, you can open carry. But if you're not doing one of those exceptions, you cannot open carry. And remember, there's a presumption on you to prove that you're doing one of those exceptions. So if you put a fishing pole in your car and think that just because I always have a fishing pole in my car, I can tell the cops that I'm open carrying on my way to fishing, that's a burden on you. You as a defendant have to present evidence in court and trial to a prosecutor that you were on your way to fishing. It's not an exemption. It's not automatically I have a fishing pole. So just kind of keep that in mind. There are exceptions to open carry, but the burden is on you to prove those exceptions. But as a general rule, Florida does not have open carry. The new statute did not change that either. So we do not have open carry. Now, number 3, before we get to number 3 though, please like, share, and subscribe. If you like my content, please make some comments below. If you disagree with this list, if you want to add some things to this list, please do so. But like, share, and comment. It really helps the algorithm with YouTube being a gun channel. They're always trying to mess around with my numbers. So please like, share, comment, and follow the page. Now, number 3, how do you carry in your car? I get this question all the time. You can carry in your car even if you do not have a concealed carry permit, and even if you are not eligible for a concealed carry permit, as long as you're not otherwise a prohibited person. So if you're a convicted felon, for example, you can't have a gun. It doesn't matter where you're carrying it or what you're doing it. You're not allowed to have a firearm. But if you are allowed to possess a firearm, but you maybe don't meet some of the other criteria to conceal carry a firearm, you can still carry a firearm in your car, okay? The pertinent statute is 790.254A, possession in a private conveyance. A person 18 years of age or older who is in lawful possession of a handgun or other weapon may possess such a handgun or weapon within the interior of a private conveyance if the handgun or weapon is securely encased or otherwise not readily accessible for immediate use. So, again, if you can't carry concealed, that's fine. You can still have it in your car, but there are 2 things. It either needs to be securely encased or readily accessible. So you're saying, hey, MGL, what the hell do those 2 things mean? Well, the good news is Florida Statute 790.001 tell you what those mean. So subsection 14 defines readily accessible for immediate use. Means that a firearm or other weapon is carried on the person or within such close proximity and in such a manner that it can be retrieved and used as easily and quickly as if carried on the person. So basically, if it's just stuffed under your seat and you can get to it as quickly as you could if you were carrying it, that's going to be considered readily accessible for immediate use, so you can't do that. If it happens to be stuffed under the way back seat, and you physically, with the seatbelt and the way your car is designed, you physically cannot reach back there to get it, you could make an argument that it's not readily accessible. But remember, much like the last example that I gave, the burden is going to be on you to try and prove that it's not readily accessible and that you can't reach that gun. It's not going to be something that the cops are going to debate you on the side of the road for. Subsection 15 of that same statute defines what securely encased means. In a glove compartment, whether or not locked, snapped in a holster, in a gun case, whether or not locked, in a zippered gun case, or in a closed box or container, which requires a lid or cover to be open for access. So basically, put it anywhere that it's in some sort of a closed compartment. You can put it in your center console. You can have it loaded, cocked and locked, ready to go, and not even lock the center console, as long as it's in the center console with the lid down. You can put it in the glove compartment, cocked and locked, loaded, ready to go, as long as the compartment is closed and it's shut. Basically, you just can't be able to just have it laying on your seat. You can put it in a container. You can put it in a zipped up gun case. They don't have to be locked. Your gun can be loaded. That's another thing I hear all the time is, well, it has to be unloaded. No, it doesn't. You can have a fully loaded, one in the chamber, ready to go gun, as long as it is securely encased in one of the things. Holsters are a big question that I get. Snapped in a holster, and the case law is consistent. It says it has to be a holster with a snap on it. If you put it in a retention holster, even though it's clipped and you can shake that thing up and down and the holster won't, and the gun won't fall out of the holster, that's not going to be considered compliant with the statute because it specifically says snapped. I've argued that issue before and unsuccessfully. So there you go. You can carry it in your car as long as you meet those statutory conditions. The number two gun law is we do have stand your ground here in Florida. You've probably heard it all over the news because people on the left and people who don't like guns always despise stand your ground and they want to bring it up all the time. But we do have what's called stand your ground here in Florida. What that means is as long as you are in a place that you have a right to be, you don't have to retreat in order to use deadly force. It used to be, before we had stand your ground, that if you're walking down a sidewalk perfectly legally to be there and a bunch of guys confront you, you first have to try and retreat. You have to try and run away. You have to look for an exit. You got to do something before you can go to using self-defense. They changed that law, and now as long as it's a place you have a right to be, you can stand your ground. If it's somewhere you don't have a right to be, you're trespassing or whatever, or you're somewhere committing a crime, selling drugs or whatever, you're not going to be able to claim stand your ground. You have to lawfully be doing something that's lawful, and you have to be in a place that you lawfully have a right to be. As long as you're doing that, you don't have a duty to retreat, okay? So the stand your ground section is statute 776.012. A person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat before using or threatening to use force. That's all stand your ground means. It doesn't change anything else about the self-defense laws, except you don't have to first try and retreat. That leads me into the number one rule. The number one rule that you should know about guns in Florida is the standard for when you can use one, okay? In Florida statute 776.012 defines use or threatened use of force in defense of a person. Okay? This is basically what it says. A person is justified in using or threatening to use force, including deadly force, if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. So those are the two times you can use it. You have to be an imminent threat of death or great bodily harm to yourself or to another, and you have to be wanting to prevent the commission of a forcible felony. Now, that statute also has a definition of what a forcible felony is. It's all the things that you would normally know, murder, rape, kidnapping, carjacking, things along those lines. But again, remember, just because a forcible felony applies, it still has to be reasonable. Again, listen to what it says. If he or she reasonably believes that using or threatening the use of force is necessary to prevent it. So even if you see a forcible felony going on, a jury could still decide that even in that situation, it wasn't reasonable for you to use deadly force. It's not an automatic thing. Hey, there's a carjacking going on over there. I get to pull my gun. You're still going to be held to the reasonably believes standard. Same thing with imminent threat or bodily harm. Imminent means right now, basically, you are an imminent threat. If people are standing on the other side of the road, yelling at you, giving the middle finger, you may have a hard time saying that you're an imminent threat of death or great bodily harm because they're on the other side of the road. If you're in a road rage incident and people are driving next to you on the side of the car, you're in your car, the doors are locked, you have your cell phone right there to call 911, you may have a hard time trying to explain that you are in imminent fear of death or great bodily harm. So we do have a high standard for using deadly force, either threatening or using to do it. And you need to remember you must be in imminent danger or there must be an imminent commission of a forcible felony, but you will always be held to the reasonable belief standard. So if you're ever going to use a firearm in Florida, you need to read that statute and make sure you know what the rules are. So there you go. Those are my top 5 important gun laws that you need to know for the state of Florida. I hope you enjoyed them. If you disagree, please comment down below and let me know. If you agree, you can comment down below and let me know that as well. But that's it for today. Thanks for watching. As always, stay safe, stay healthy, and carry on.